civilians were killed, and a shocking 41% of these were women and children. A proper and holistic interest of justice assessment would have addressed ways in which the state parties can devote more sums to international justice. The prosecutor can at any time submit a supplementary request for resources to the Assembly of States Parties. And as Mr. Scheffer suggested in his 15 November amici curiae observations to this chamber, the appeals chamber is also in a position to call upon the states parties to make available the necessary resources. To conclude, Your Honours, rigorous investigation and prosecution of crimes is one step to ensure greater respect for the rule of law in Afghanistan. A strengthened rule of law is surely likely to, in turn, ensure a more genuine realization of the victims' interests. Thank you, Your Honours. I'll now give the floor to Mr. Gaynor.
Thank you very much. Your Honours, I will not address in very great detail the question as to whether the pre-trial chamber erred in restricting the scope of the prosecutor's investigation in light of Ms. Brady's submissions today. We agree really with almost everything that she said. We would add to what she said that both the prosecutor and the chambers have truth-seeking duties under the statute, and the ability to seek the truth is obviously easier to carry out when the remit of the investigation is broad than when the remit of the investigation is narrow. We add to that the fact that the prosecutor is obliged to uncover both incriminating and exonerating evidence. And again, it's easier to find and identify witnesses and to pick up documentary evidence and all other kinds of relevant evidence where the remit of the investigation is broad rather than narrow. I'd like to take this opportunity to address some of the submissions made by my learned friend, Mr. Dixon, on behalf of the government of Afghanistan, and some of the submissions made in the written submissions of the government of Afghanistan. Mr. Dixon gives the impression, if I might suggest, that the government of Afghanistan has been shut out of the preliminary examination and nobody wants to listen to what they have to say. Well, my understanding from reading the prosecutor's preliminary examination reports, which are released about this time every year, is that the government of Afghanistan has in fact been in constant contact with the prosecutor, and the prosecutor has very properly asked the government of Afghanistan to let it know what it has been doing in respect of the investigation and prosecution of crimes within Afghanistan. And so there really has been every opportunity. The preliminary examinations report for 2016, for example, refers to the Office of the Prosecutor said that the government has not provided any information of national proceedings to the office against Afghan government forces, despite, quote, multiple requests for such information from the OTP since 2008. End of quote. That's the preliminary examination report of 2016. So really the government of Afghanistan has had every opportunity to bring before the Office of the Prosecutor and in turn through them to the pre-trial chamber its information concerning the investigations and prosecutions that it's carrying out in respect of alleged crimes by its own forces, by international forces, by Taliban and associated groups, and by ISIS. Now, Mr. Dixon would like us not to get into the detail of Article 17.2 and 3, but frankly we have no option given that, in particular, our ability to respond to these issues tomorrow has recently been ordered by Your Honours off the calendar, so I have no option but to respond today. Now, 17.2 of the statute concerns where there has been unjustified delay in the proceedings which in the circumstances is inconsistent with an intent to bring the person to justice. That is absolutely relevant. Mr. Dixon refers to the 11-year period of the preliminary examination and says, well, too much time has passed, it's now time to move on. Well, that's absolutely contrary to the victim's interests. There is no statute of limitations in respect of war crimes, crimes against humanity and genocide. It is absolutely in the victim's interests that the investigation and prosecution of these matters should take place. Another question to be considered here is the I'm still on willingness. The willingness. Is Afghanistan willing to carry out investigations and prosecutions? This is particularly important in respect of two groups of people. The first is Afghan government forces, and the second is international forces for crimes against Afghan civilians on the territory of Afghanistan itself. In respect of the Afghan government forces, these are paid by the government of Afghanistan, they're fed by the government of Afghanistan, they are housed by the government of Afghanistan. The government of Afghanistan certainly has access to these individuals. It has its own military justice system, and yet in all of the oral and written submissions by Mr. Dixon and by His Excellency the representative for the government of Afghanistan, we see one reference to one prosecution of one case against one member of the Afghan government forces, and that relates to the murder and rape of a boy. Now, that single example, absolutely fine. It's good that that took place, but that is not indicative of a genuine willingness to investigate and prosecute crimes by Afghanistan government forces generally. Second, we've seen no indication from the government of Afghanistan of a willingness to investigate crimes allegedly committed by international forces on the territory of Afghanistan against Afghanistan citizens. Then we have to move to 17.3, and this concerns inability. Mr. Dixon essentially characterized the 17.3 test as, is Afghanistan a failed state or not? And with respect, that is not the test set out in 17.3. 17.3, the first part of it, I'll read it verbatim, quote, in order to determine inability in a particular case, the court shall consider whether, due to a total or substantial collapse or unavailability of its national judicial system, and I'll stop there for a moment, what we do have in Afghanistan is a substantial collapse or unavailability of the national system. And that's absolutely clear from the submissions made on the government's behalf today. And it's also clear from some of the submissions which were made in the report of the government of Afghanistan itself. The government said, for example, at paragraph 24 of its submission of the 2nd of December 2019, it said, quote, the reality is that Afghanistan remains in the middle of a brutal armed conflict marked by guerrilla warfare and suicide bombing. They go on to say, attacks by the Taliban and other armed groups continue to cause heavy casualties. As a result, there are many parts of Afghanistan in which it is simply not safe to conduct investigations, close quote. Now, the government has referred many times, and my colleague Ms. Kiswanson earlier referred to the murder of police prosecutors and judges in Afghanistan. So all of these factors must be taken into account, and I think the conclusion which we must all, with great regret, reach is that there has been a substantial collapse and unavailability of the national judicial system. Now, I just want to carry on reading from the test set out in Article 17.3 of the statute. The test goes on to read, quote, the state is unable to obtain the accused or the necessary evidence and testimony or otherwise unable to carry out its proceedings. And again, I would refer to the written submissions of the government of Afghanistan. And in those written submissions, I don't have the precise quotations to hand, but it is quite clear that the government of Afghanistan, its own position is that it is not able to access suspects and accused on its own territory for the very reason, as has been pointed out by many, is that the Taliban itself controls a significant proportion of the territory of Afghanistan. The non-control of a significant proportion of the territory of the state party in this question, when assessed in combination with the systematic attacks on police, prosecutors and judges, means, in essence, inevitably and very regretfully, that the necessary evidence and testimony is simply not available to the government of Afghanistan in order to carry out its proceedings. Now, what is the procedural remedy for all this? The procedural remedy is for Afghanistan to bring an admissibility challenge at the correct moment. That we can then have a full hearing. I'm not asking Your Honours to conduct an admissibility challenge right now. But the right thing to do is for Your Honours to authorise the commencement of the investigation on the basis of the findings by the prosecutor that Afghanistan is both unable and unwilling to effectively investigate and prosecute. And then Afghanistan can bring a proper admissibility challenge. It can bring to the court clear evidence of a genuine, not just willingness, but an ability to investigate and prosecute its own forces for crimes committed against Afghan civilians. It can also bring evidence, which has been absolutely absent so far, of its own willingness and ability to investigate and prosecute international forces for crimes against Afghan civilians. And it can also make full and informed submissions concerning whatever proportion of the territory of Afghanistan is at that time under Taliban control or under the control of other anti-government forces. So I would suggest that that is the proper procedure to be followed. Mr. Dixon and the representatives of the government of Afghanistan can then come back before the pre-trial chamber and make full submissions on admissibility. I don't believe I have anything else to add. Thank you very much, Your Honours.
Thank you very much, Counsel. We'll move to legal representatives of Victims Group 2. And as I understand, there are 3 speakers, and you will share the time allocated to the group. That's together 40 minutes, please proceed.
Mr. President, as Your Honours, as my colleague for Legal Representative of Victims 1 indicated, I intend to focus on the question CA, the first question under C, namely, when the prosecutor requests authorisation to initiate an investigation having considered Article 53(1)(c) of the statute, does the pre-trial chamber have the power to consider the factors under Article 53(1)(c) of the statute itself? It's submitted that the pre-trial chamber erred when denying the request for the prosecutor by concluding at paragraph 35 that the scrutiny mandated to the pre-trial chamber in the proceedings under Article 15 is not limited in determining whether there is a reasonable basis to believe that crimes under the court's jurisdiction have been committed, but must include a positive determination to the effect that investigations would be in the interests of justice. And it is submitted that the statute does not empower a pre-trial chamber to decide that an investigation is contrary to the interests of justice when the prosecutor has not made that assessment. Instead, a pre-trial chamber is only ever at most empowered to review a prosecutor's decision not to initiate an investigation because it would not be in the interests of justice. As a basic starting point, we say that that is clear from the plain words of the statute when one looks at Article 53(3)(a), dealing with the request by a state under Article 14 or the Security Council under Article 13. It reads that the pre-trial chamber may review a decision of the prosecutor under paragraph 1 or 2 not to proceed and may request the prosecutor to reconsider that decision. There's a slightly different mechanism within 3B, where it reads that in addition, the pre-trial chamber may on its own initiative review a decision of the prosecutor not to proceed if it is based solely on paragraph 1C or 2C. And it differs in saying that in such a case, the decision of the prosecutor shall be effective only if confirmed by the pre-trial chamber. So we say that the statute is unambiguous and explicit in only providing the power to the pre-trial chamber to review a decision of the prosecutor not to proceed. And to expand on that submission very briefly, the statute does not accord to the pre-trial chamber the power to review a decision of the prosecutor to proceed or not to proceed. It's only not to proceed. And moreover, there is no room, we respectfully submit, for the statute to be reasonably read as being silent as to whether the pre-trial chamber has the power to review a decision of the prosecutor to proceed. And that much goes both in relation to 53.3a, the referral, and 53.3b, the proprio mutuo. Moreover, whilst it is recognised that the appeals chamber has not decided question CA before, we say that the consistent view taken by other pre-trial chambers on Article 15 decisions, where there is reasoning as to the basis for taking the decision, is to conclude that the court may only review the prosecution decision on interests of justice where the prosecutors decline to prosecute on that basis. And we submit that the reasoning supporting such a conclusion in those previous Article 15 decisions of the pre-trial chamber is compelling and unassailable. We say with the greatest respect to Ms Brady that we need to significantly qualify the assertion that all previous decisions of the pre-trial chambers in relation to Article 15 looked at all the 53.1a to c considerations. So far as the Kenya decision was concerned in 2010, we note that the Kenya reasoning was rigorous and thoroughgoing. It analysed the history of Articles 15 and 53 and the interrelationship between Articles 15 and 53. It recognised the importance of the Vienna Convention, and it recognised the review standard that the pre-trial chamber was required to apply in relation to Article 15 decisions, but said at footnotes 35 and paragraph 63, as for the assessment of interests of justice under Article 53.1c, the chamber considers that its review is only triggered when the prosecutor decides not to proceed on the basis of this clause. Indeed, unlike the assessment to be made in accordance with Article 53.1a and b, the prosecutor is not required to positively determine that an investigation is in the interests of justice, and then crucially we say, does not have to present reasons or supporting material in this respect. It's only when the prosecutor decides that an investigation would not be in the interests of justice that he or she must notify the chamber of the reasons for such a decision not to proceed, therefore triggering the review power of the chamber. The Côte d'Ivoire case in 2011, we say, builds on the analysis in the Kenyan case and in effect repeats the findings of the Kenyan pre-trial chamber. At paragraph 207, it reads, unlike subparagraphs A and B of Article 53.1 of the statute, which require an affirmative finding, subparagraph C does not require the prosecutor to establish that an investigation is actually in the interests of justice. Indeed, the prosecutor does not have to present reasons or supporting material in this respect. It's only when the prosecutor decides that an investigation would not be in the interest of justice that he or she is under an obligation to notify the chamber of the reasons for the decision. And again, to enable the chamber to exercise its power.
Excuse me, Counsel, a little bit slower, please.
I am sorry, Mr. President. It's because I was reading
the translation
from the authority.
Thank you very much.
To enable the chamber to exercise its power of review in accordance with Article 53.3b of the statute. And we say that the importance of that passage is that it elaborates that the prosecution does not have to provide material or reasons to justify the investigation as being in the interests of justice, and therefore the pre-trial chamber does not conduct a review unless it is a review of the decision to not proceed. And that would follow because there are no reasons to review, and there is no material upon which the review can be based unless there is a decision to not proceed because of Article 53.1c. We also draw some support from the Darfur situation, document 185, we see that the principle was established in a different context before, and this precedes both the Kenya and Cote d'Ivoire decisions in the Darfur case, because that case was primarily concerned with the issue of whether an arrest warrant should be issued. The pre-trial chamber observed at paragraph 18 that the prosecutor had been given by the state's parties the discretion to decide whether or not to request the initiation of a case, and one of the factors it must consider is whether or not it would be detrimental to the interests of justice to do so. At paragraph 19, the court then assessed the extent to which the state's parties have provided the chamber with the power to review the prosecution's exercise of its discretion. And at paragraphs 20 and 21, the pre-trial chamber said, the chamber observes that Article 53(3)b of the statute expressly provides for the chamber's proprio motu review of any prosecutor's decision not to proceed, which is based solely on the interests of justice. And it goes on at paragraph 21, no matter whether the chamber's review power under this provision is only applicable in relation to the prosecution's decision to put an end to the investigation of a given situation, or whether it is also applicable in relation to each prosecution's decision not to prosecute a specific individual. The chamber emphasises that Article 53(3)b of the statute only confers upon the chamber the power to review the prosecution's exercise of its discretion when it results in a decision not to proceed. And that approach reflects practicalities, we say, of the operation of the statute, because there is no mechanism for the prosecution to be required to give reasons as to why an investigation is in the interests of justice. All that exists is that duty in a negative position. And therefore, the mechanism for the review of the decision, that, taking into account the gravity of the crime and the interests of the victims, there are none less substantial reasons to believe that an investigation would not serve the interests of justice, is only created by virtue of the prosecution making the negative decision and informing the pre-trial chamber of it. So it's framed in that negative way in the statute, and on a practical level in this case, there was nothing on which a review might be based, because the pre-trial chamber in this case did not require any interests of justice justification from the prosecutor for initiating the investigation. And consequently, we say that the pre-trial chamber in this case did not carry out a review. There was nothing to review. We say that the pre-trial chamber simply made a de novo decision about the interests of justice. And one final point in just this section, and then I've just come to conclude on the review function. On the importance of the negative assessment of interests of justice, it's demonstrated really by what we say is the final sentence of Article 53(3), which reads, in such a case, the decision of the prosecutor shall be effective only if confirmed by the pre-trial chamber. The process is one of confirming a decision not to commence an investigation. The whole of this part of the article speaks of the decision of the prosecution to not proceed on the basis of 1C or 2C, and links the last sentence by saying, in effect and in reality, in addition, the pre-trial chamber may, on its own initiative, review a decision of the prosecutor not to proceed if it is based solely on paragraph 1C or 2C. In such a case, the decision of the prosecutor shall be effective only if confirmed by the trial chamber. Thus, the decision to not proceed is only effective if confirmed by the pre-trial chamber. It does not stipulate that the decision to proceed shall only be effective if confirmed by the pre-trial chamber. And finally, just to return to the question of what review means, there must be a review of the decision. It isn't simply a de novo decision-making process. And if I may say with respect, paragraph 16 of the opinion of Her Honour Judge Fernandez in the Cote d'Ivoire case, and indeed paragraph 18, makes that point. Mr. Dixon referred to reviewing by domestic states, or the standard of review of the prosecutorial discretion in some domestic states is very strict, and rightly so. And just to take the example of England and Wales, the threshold for judicial review of a prosecution decision, even to not prosecute, is extremely high, and the courts do not take the view that the consideration of the interests of justice is for them let alone that it can only ever be for the cause. There has never been a successful judicial review of a Crown Prosecution Service decision to prosecute in England and Wales. And indeed, the Crown Prosecution Service guidance on judicial review of prosecutorial discretion in England and Wales says the following: the authorities are now clear. In the absence of exceptional circumstances, the decision to prosecute will not be amenable to judicial review in the High Court, as the arguments can be dealt with within the criminal trial in the Magistrates' Court or Crown Court. Such exceptional circumstances might be dishonesty or mala fides on the part of the prosecutor, but one might argue that the law on abuse of process is sufficiently developed to deal even with those circumstances. So we therefore submit in conclusion that by assuming a power to assess the interests of justice in circumstances other than to review the prosecutor's discretionary decision not to investigate, the pre-trial chambers acted ultra vires in this case.
Good afternoon, Your Honors. To respond to question CB, asking whether the pretrial chamber considered appropriate factors and drew appropriate conclusions about those factors in determining that an investigation would not be in the interests of justice, an assessment I fully join my colleague in arguing is one a pretrial chamber cannot carry out when the prosecutor has found an investigation serves the interest of justice. The answer is clearly no. Beyond this legal conclusion that the factors are inappropriate for the pretrial chamber to consider, I would like to explain why these factors, in this situation, and indeed possibly in future cases, should the investigation be authorized. I will go through each of them and give our reactions to them, and that is from the perspective of the victim's interests. First, regarding the purported significant time elapsed, the U.S. torture victims certainly would have preferred that the request was filed much sooner than it was. Likewise, they would have preferred not to have waited nearly a year and a half for the pretrial chamber to issue its 30-page decision denying the request to open an investigation. As for the delay being caused to forgo an investigation, I respectfully submit that this issue has been adequately addressed in the briefing by the parties, by the legal representatives for the victims, and by amici's briefing. Successful investigations and prosecutions in which the rights of all parties are respected have been conducted with a far larger time gap than exists with the U.S. torture program. But it is also a mistake to consider that the U.S. torture program is fully over. 40 men who went through the global detention network remained imprisoned today at Guantanamo Bay. My clients, like many others, have never been charged with a crime and so remain in the same indefinite detention they endured on the territory of states parties. For Mr. El-Haj, that includes 23 months on the territory of Jordan in proxy detention in 2002 and 2003, before being transferred to Afghanistan, where his enforced disappearance continued for 8 months until he was transferred to Guantanamo in August 2004. For Mr. Duran, he was seized by Djiboutian security forces while transiting through Djibouti in 2004, turned over to the CIA, and at some point between March 2004 and September 2006, that information is classified, he was detained and tortured in Afghanistan. Furthermore, my clients and other prisoners are not on the territory of a state party now. While they're not on the territory of a state party now, the severe mental harm, if not also the physical harm, that they endured on the territory of Afghanistan, or Poland, or Lithuania, or Jordan, or Djibouti, as well as other state parties, has been continuous. I pause to note briefly here that contrary to the pretrial chamber's focus on, quote, capture, as somehow separate and apart from torture in its flawed nexus analysis in paragraphs 53 and 54. The capture and abduction, the kidnapping and enforced disappearance are part of the criminal conduct, including torture, not merely antecedents to it. Most fundamentally, however, the gap in time has not eliminated either the need or the yearning for accountability and justice for these victims and for so many others. Regarding state cooperation, the parties have also fully briefed why the pretrial chamber was wrong to speculate about the extent of state cooperation before an investigation was authorized. 3 further points for the chamber to consider. Cooperation from the United States, a non-state party, is not necessary for a successful investigation of U.S. torture. U.S. government reports, including the Senate Torture Report, memoranda, legal memos, and statements by former U.S. officials in the public domain, provide ample investigatory leads, if not evidence. As stated yesterday, the U.S. torture program was global in nature. The sad and disturbing reality is that far too many countries, including dozens of ICC member states, provided assistance to the United States, allowing use of airspace, refueling stations, sharing of intelligence, holding victims in proxy detentions, or hosting secret black sites. We know this in large part because of investigations done by Dick Marty for the Council of Europe, or the 2010 Joint Study on Global Practices in Counterterrorism Operations by former UN Special Rapporteurs Manfred Novak and Martin Scheinin, or through the work of the Open Society Justice Initiative and the Rendition Project. The prosecutor might be starting this investigation late, but she certainly won't be starting at step 1. Unlike the United States, member states do have an obligation to cooperate with an ICC investigation, and as a result of their own involvement, are a rich source of information: memos, cables, flight plans, meeting readouts, satellite imagery, just to name a few. And respectfully, I submit most critical for the legitimacy and success of the International Criminal Court, the perception, the widely held perception, that the pretrial chamber foreclosed the investigation because of U.S. bullying, fed in no small part by the timing of the decision after such a long delay, as well as the pretrial chamber's own reference to, quote, the political landscape, or, quote, the political climate, sends a dangerous message that the easiest way to kill an investigation or a case at the ICC is obstruction and threats. The impugned decision stands in stark contrast to the decision by the pretrial chamber considering whether to permit an investigation in Burundi. There, despite the prosecution's assertion that the government of Burundi had, quote, interfered with, intimidated, or harmed victims and witnesses, the pretrial chamber proceeded to authorize the investigation. Regarding the availability of evidence and suspects during the investigative phase, I touched on this part in discussing member states' cooperation briefly. I would only add that the victims of CIA and DoD detention themselves are key sources of potential evidence for the prosecution. Indeed, today's New York Times has sketches newly cleared for release from Abu Zubaydah, one of the CIA detainees, detailing his own torture. As for suspects, and I use that term carefully, many key figures in the U.S. torture program continue to maintain a public presence or even a public role, public official function. It might be surprising for the court to hear that some speak without reservation about their role in the torture program. Such is the reality when impunity reigns. The sworn testimony of some participants in the torture program is also available as a result of proceedings in U.S. courts. For example, the ACLU civil case, Salim v. Mitchell, led to the sworn testimony of CIA contractors James Mitchell and Bruce Jessen, 2 psychologists contracted by the CIA to design and implement its torture program, as well as that of 2 former CIA officials, John Rizzo and Jose Rodriguez. Notably, Mitchell and Jessen have been called to testify before the U.S. military commissions at Guantanamo in January in the context of a defense motion to suppress evidence alleged to have been obtained under torture. That examination and cross-examination could well be available to the prosecution. Finally, on resources, I will only highlight that the statute requires compliance with the fundamental human right of non-discrimination. It's recalled that all of the individuals in the U.S. torture program were Muslim or perceived to be Muslim. Victims should not be denied justice because of their religion, national or ethnic origin, race or other status. And likewise, potential defendants should not escape liability because of theirs. It's important to note that the factors the pretrial chamber did not include. First and foremost, there is no discussion on the object and purpose of the ICC and the Rome Statute system: to end impunity for grave crimes and thus to contribute to the prevention of such crimes. That is the purpose of this system. As I said yesterday and will repeat today, because there were questions raised, the United States has been wholly unwilling to hold any senior U.S. official accountable for the U.S. torture program. No one member of the CIA has been prosecuted for the serious crimes you heard about yesterday. And the United States has not taken up this chamber's invitation to appear in these proceedings and confirm its commitment to accountability. Moreover, the United States has often intervened in even civil lawsuits to try and block victims for redress, and as we learned a number of years ago through WikiLeaks cables, actively interfered with criminal investigations brought in other countries under universal jurisdiction. Quite simply, if the United States doesn't want to come before the ICC, it has 2 choices: prevent its citizens, and especially members of its military, intelligence services, and senior officials, from committing serious violations of international law on the territory of the 122 member states of the ICC. Or hold those citizens, including senior officials, accountable if such violations have occurred, and cease the harm to the victims, provide an apology, and redress. But the choice of factors was not the only error by the pretrial chamber. If the pretrial chamber was going to step into the role of the prosecutor and make a determination as to whether an investigation would not serve the interests of justice, which again, we submit was a legal error, then it should at least have to follow the weighing of gravity and victims' interests on the one side versus interests of justice on the other, as set forth in Article 53(1)(c). And in order to foreclose the investigation, conclude that its interest of justice factors, quote, nonetheless constitute, quote, substantial reasons to override victims' interests and the gravity of crimes. The pretrial chamber engaged in no such assessment. If it had, I submit the pretrial chamber's interest of justice factors would carry very little weight, and certainly not constitute substantial reasons to believe an investigation supported by the victims into U.S. torture would not serve justice. Yesterday, you heard in some detail the specific conduct to which victims of the U.S. torture program were subjected. Those facts were not presented for shock value, but rather to inform your honors about the gravity of the crimes. They also demonstrate that the torture program was not the product of a few bad apples or mere excesses by some soldiers. They constitute war crimes and crimes against humanity, which is what we put forward in our victims' representations. Had the pretrial chamber examined the gravity of the crimes without the legal error regarding nexus to the armed conflict, which colleagues will discuss, it would have concluded that the scale of the criminal activity in the situation, the length of time over which it occurred, the level of depravity employed, and the widespread and systematic manner in which this criminal enterprise was carried out warrants the attention of the investigation by the International Criminal Court. As the OPCV rightly explained yesterday, the pretrial chamber did not take victims' interests into its interest of justice assessment. Rather, in paragraph 96, it flipped victims' interests on their head, and again, inappropriately replaced the views of another group, here, the victims, with its own opinions. Thank you very much, Your Honors.
Yeah, thank you very much. So I understand you have still 10 minutes to make submissions.
Mr.
Please
President,
proceed.
Your Honors, good afternoon. My remarks focus on a dimension of the merits of this appeal, glaring legal errors which were omitted by the prosecution in its oral submissions today, but thoroughly covered in its appeal brief at pages 44 through 53, with which LRVs concur, and which are not directly mentioned in Your Honor's questions, but which we respectfully submit demand this Chamber's attention because of their dangerous implications and premature exclusion of crimes within the jurisdiction of the court from any investigation that may be authorized. The impugned decision includes egregious errors of law regarding the court's subject matter and territorial jurisdiction over the war crime of torture. The decision replaces sound and accepted analysis consistently applied in this court's prior jurisprudence with distortions of international humanitarian law. As we said yesterday, these errors have the effect of writing our client and many other victims of the U.S. torture program out of the scope of any investigation by the prosecutor. Moreover, if uncorrected, these errors would have the perverse, and we posit unintended, effect of endorsing the repugnant logic that formed the basis for the U.S. torture and extraordinary rendition program. Among the most glaring errors was the pretrial chamber's misinterpretation of the court's territorial jurisdiction over the war crime of torture when that crime occurred in part on the territory of a non-state party. The issues are complex and, with all due respect, are made more confusing by the pretrial chamber's muddled approach to its analysis. We will not repeat here the extensive discussion of these issues in the filings before the chamber, but we'll try to restate in simple terms what we submit the pretrial chamber got so terribly wrong. But let's start first with what the pretrial chamber got right. In paragraph 50 of the decision, the pretrial chamber correctly stated that if any part of a crime is committed on the territory of a state party, whether it commences, continues, or concludes there, the court has jurisdiction under Article 12. But the pretrial chamber then plainly failed to apply that understanding of the law when reviewing the aspects of the prosecutor's request concerning torture committed by U.S. actors. This was largely because the pretrial chamber misconstrued the conduct at issue, that is, the elements of the crime of torture, and how it was committed under the U.S. torture program. As my colleagues in LRV 3 will elaborate, the impugned decision abandoned long-accepted, fact-specific criteria under international humanitarian law concerning the nexus between given criminal conduct and armed conflict, criteria clearly set out in the June 15, 2017 Ntaganda appeal, decision 1962. We submit that had these well-established criteria been applied to the facts relevant to our client and many other victims of the U.S. torture program, the pretrial chamber would have found a reasonable basis to conclude that a nexus to the armed conflict existed. Instead, it focused on the locus of capture as the sole determinant of the requisite nexus. To restate in plain language the pretrial chamber's erroneous conclusions in paragraph 54 and 55 of the decision, on the one hand, the chamber said that if a person was captured outside of Afghanistan and then brought to Afghanistan and tortured, the crimes committed against him cannot amount to war crimes within the court's subject matter jurisdiction because it's the locus of capture alone that determines the nexus. On the other hand, it held that if a person was instead captured in Afghanistan but sent to the territory of a non-state party to be tortured, the crimes committed against him would not be within the territorial jurisdiction of the court. This dangerous conclusion appears to have rested on a fundamental misunderstanding of the facts and operation of the U.S. torture program. As I described yesterday in presenting the abuse suffered by our client, capture in the torture program systematically entailed kidnapping, sexual assault, and incommunicado detention before transfer to a secret location for interrogation under further torture. As Ms. Gallagher emphasized, cleaving off capture from subsequent acts of torture and referring to it as a mere antecedent misunderstands the continuous nature of the crimes, which were part of a coordinated, orchestrated transnational program, or, to use Ms. Gallagher's words, a criminal enterprise. The pretrial chamber's confusion on this point is especially troubling since the U.S. torture program was designed to exploit purported lacunae in human rights and humanitarian law, and to avoid the jurisdiction of courts, whether domestic, foreign, or international, that might otherwise shut the program down. Through misguided interpretations of international law, the United States sought to place detainees in a legal black hole, while also physically moving them to prisons chosen or constructed to avoid the jurisdiction of courts that might view the law differently. Particularly relevant to the impugned decision here, the U.S. maintained that the protections of Common Article 3 of the Geneva Conventions did not apply to armed conflicts that were international in scope. We will not repeat what is well known. These legal arguments have been roundly rejected by courts that have had the opportunity to review them since the U.S. launched its torture program many years ago. The U.S. Supreme Court, the European Court of Human Rights, the UN Human Rights Treaty bodies, and the Inter-American Commission on Human Rights have all determined that no legal black hole ever existed, that the protections of Common Article 3 applied to detainees held by the United States in its secret prisons, and that they unquestionably had the right to be free from ill treatment and torture. The pretrial chamber's mistaken conclusions regarding the war crime of torture are not only legally unfounded and grossly underprotective, they also resuscitate condemned legal arguments precisely at the time in the United States when there is a manifest risk of recurrence. Allowing these aspects of the impugned decision to go uncorrected would put the ICC's imprimatur on the very logic underpinning the infamous torture program. We respectfully request that the Chamber correct these legal errors in its decision on this appeal, reverse the impugned decision, and authorize the commencement of an investigation into the situation in the Islamic Republic of Afghanistan that encompasses the severe violations our client and other victims of the U.S. torture program suffered. With all due respect, we note the conspicuous absence from the remarks by the representatives of Afghanistan of any evidence of efforts to investigate or prosecute crimes committed by U.S. actors in Afghanistan. Our client has been denied justice for nearly 15 years since his release from U.S. custody in Afghanistan. We ask this chamber to carry out its role as a victim-centered court of last resort and authorize the investigation into the situation in the Islamic Republic of Afghanistan. Thank you.
Thank you very much, Counsel. Move to legal representative group 3. We have 2 speakers, I understand. Please proceed. Your 40 minutes begins now.
Thank you, Your Honors. Mr. President, Your Honors, as legal representatives, excuse me. Your Honors, as legal representatives of Mr. al-Nashiri, referred to by the court as LRV3, We have been filing our written submissions together with 3 other legal representative teams who have been referred to by the court as LRV2. We maintain our position presented in these submissions, and we join the arguments presented by our colleagues during today's hearing. I wish, however, to make a few remarks concerning ground 4 of the LRV's joint appeal, concerning the pre-trial chamber's determinations of the court's jurisdiction over the crimes committed as part of the U.S. torture program. I will try not to repeat the submissions that have been already made before the chamber today. However, I will try to focus on specific aspects that are of particular importance to our client. Mr. President, Your Honors, we submit that the pre-trial chamber prematurely and erroneously excluded from the court's jurisdiction criminal acts arising out of the U.S. torture program, including crimes committed against Mr. al-Nashiri. We submit that these determinations should not only be considered as affecting factors that the pre-trial chamber took into account in assessing the interests of justice. Neither can they be described as mere obiter dicta. Had the pre-trial chamber decided that the investigation would serve the interests of justice, its remaining determinations on jurisdiction and admissibility would remain valid. Your Honors, the pre-trial chamber's erroneous determinations that were clarified to you from our reading by my colleague, Ms. Reich, were categorized by the pre-trial chamber as determinations concerning territorial jurisdiction of the court. However, the reasoning of the pre-trial chamber shows that in reaching these conclusions, it had conflated material with territorial jurisdiction. As noted by Ms. Reich, it erroneously restricted the scope of the application of Common Article 3 of the Geneva Conventions to the non-international armed conflict in Afghanistan by limiting its application only to the territory of Afghanistan. The appeal brief of Office of the Prosecutor explains in detail these failures of the pretrial chamber, and we join this argument and support it. The pretrial chamber disregarded the fact that the crimes in question have a cross-border and continuous nature, that their individual elements cannot be considered separately, in isolation, without warping the picture of the crimes and victimization of Mr. al-Nashiri and many other victims of the U.S. torture program. Your Honors, I will focus my further remarks on the pretrial chamber's determinations concerning the link between the crimes committed as part of the U.S. torture program and the conflict in Afghanistan, as well as on the continuous and cross-border nature of these crimes. Your Honors, the pretrial chamber made its determination on the link between the crimes committed as part of the U.S. torture program and the conflict in Afghanistan in part of the impugned decision titled Territorial Jurisdiction. The pretrial chamber found that the link between the crimes of the U.S. torture program and the armed conflict in Afghanistan can be determined based only on the location of the acts of capture. This means, according to the pretrial chamber, that torture of Mr. al-Nashiri does not fall under the court's territorial jurisdiction because he was captured in Dubai. For the pretrial chamber, it is irrelevant that he was then transferred to and tortured in multiple state parties to the Rome Statute, specifically Afghanistan, Poland, Romania, and Lithuania. This determination is legally erroneous. The link to an armed conflict is one of the material elements of the war crimes of torture. The factors that are to be taken into account in assessing this link have been explained in the jurisprudence of the Appeals Chamber and the Antaganda case in the judgment referred to by my colleague Ms. Reich. This judgment refers to the well-established factors that were noted in the ICTY judgment in the Kunaraj case. Your Honors, these factors include whether perpetrator is a combatant. They include assessment of whether the victim is a member of opposing party or a non-combatant. They include and necessitate assessment of whether the act which was committed served ultimate goal of military campaign. These factors include also assessment of whether the armed conflict played a substantial role in the perpetrator's ability to commit the crime. These factors do not include location of the crime or of its mere antecedents, as the acts of capture are referred to by the pretrial chamber. Your Honors, interestingly, the pretrial chamber makes reference to the paragraph of the judgment in the Ntaganda case, which lists those factors. However, it fails to take them into account. Your Honors, we submit that had the pretrial chamber applied the correct factors to determine the nexus element, it would have determined that there is a reasonable basis that acts of torture in question fall under the scope of the court's jurisdiction. It would have determined that the acts of torture committed under the U.S. torture program towards Mr. al-Nashiri and other victims would fall under this court's jurisdiction. Your Honors, I will turn now to the pretrial chamber's limited and erroneous understanding of acts of torture committed as part of the U.S. program. Your Honors, it is unclear why the pretrial chamber, in its assessment of the court's jurisdiction over the crimes of torture we focus on, why the pretrial chamber focuses only on the location of the act of capture, the mere antecedent, as the chamber refers to this act, of the crime of torture. As I noted earlier, it is not a factor based on which one can determine whether a nexus between acts of torture and the armed conflict in question exists. If singled out, it is also irrelevant when assessing territorial jurisdiction of the court over the act of torture. This is because the acts of torture committed as part of the U.S. torture program are not single, separate acts. Yesterday and today, we have heard detailed descriptions about the acts of torture that the pretrial chamber excluded from the court's jurisdiction. These are acts which are continuous crimes. Mr. al-Nashiri was captured, transported multiple times to different locations, not knowing where he is going, for what purpose, and for how long. In each of these locations, he was held in incommunicado isolation. His torture started with his capture in late October 2002 in Dubai and continued for almost 4 years through Afghanistan, Thailand, Poland, Morocco, Cuba, Romania, Lithuania, Afghanistan again. Since September 2006, he remains a prisoner in Guantanamo Bay military prison without access to any effective remedy to seek justice. His torture, illegal and incommunicado detention continued for years and crossed multiple borders, along with his forced and extralegal transfer across those borders. To understand the complex, continuous nature of torture and ill-treatment committed as part of the U.S. torture program, it is important to refer here to the background paper on CIA's combined use of interrogation techniques of 30th December 2004. We refer to this paper in our joint brief in footnote 201. The paper explains that effective interrogation is based on the concept of using both physical and psychological pressures in a comprehensive, systemic, and cumulative manner to influence high-value detainees' behavior, to overcome a detainee's resistance posture. The goal of interrogation is to create a state of learned helplessness and dependence. The paper explains that the interrogation process is broken into 3 separate phases: initial conditions, transition to interrogation, and interrogation. Initial conditions phase consists of capture shock, rendition, and reception at black site. The paper states that capture is designed to contribute to the physical and psychological condition of the high-value detainees prior to the start of interrogation. Your Honors, based on these descriptions, it is clear that the US torture program was intended to conduct continuous torture over detainees. A correct assessment of the court's jurisdiction requires taking into account the entire system of abuse and crimes as an organized and connected set of criminal actions conducted against Mr. al-Nashiri, but also against many other victims over many years and across many borders. Your Honors, the pretrial chamber in the Bangladesh situation has determined in its recent decision on the prosecution's request for a ruling on jurisdiction under Article 19.3 of the statute that the court's jurisdiction is engaged where at least one element of a crime occurs within the territory of a state party. It is our submission that the chamber erred in its determination of the court's jurisdiction over these crimes, completely disregarding the continuous character of the crimes in question. As noted by my colleagues, the US torture program was designed in a way to avoid any jurisdiction, to avoid accountability. The pretrial chamber's muddled determinations with regard to the court's jurisdiction over the crimes committed as part of the US torture program are not only unclear, but they are also legally flawed. Unless corrected, they will result in impunity. Thank you, Your Honors, and with your permission, my colleague, Mr. Mikołaj Pietrzak, will take the floor. Thank you.
Mr. President, Your Honors, as my esteemed colleague Maria Radziejowska explained, failure to change the decision of the pretrial chamber, not merely with regard to the interest of justice argument, may leave Mr. al-Nashiri and other victims of the extraordinary rendition and enhanced interrogation techniques torture programs outside of the scope of the investigation with no remedy, no effective investigation, no accountability. We reject the idea that any effective investigation could have, can be, or will be conducted by the United States of America authorities. As counsel for LRV2, Ms. Catherine Gallagher has just said, the identity of the perpetrators of these crimes is well known. We know who created and administered the torture program to Mr. al-Nashiri and other victims. They are Mr. Jessam and Mr. Mitchell and others. If there was any will on the part of the U.S. state, they could have already been arrested and charged. They could be arrested today. This has not taken place, and it is painfully obvious that it will not take place unless this court authorizes an investigation encompassing these crimes. The issues raised by the impugned decision and connected with the Group C questions, in particular regarding nexus-related issues which have already been addressed today, and the potential to leave behind victims of the extraordinary rendition and enhanced interrogation technique or otherwise torture programs, require that we address the statement made today by the representatives of the Afghan state. Even though there are no grounds to do so, if we do, in a gesture of sheer optimism, believe that the Afghan state, which has failed for so long to investigate effectively, can and will now investigate, failure to authorize an investigation by the appeal chamber to be conducted by the Office of the Prosecutor on the grounds of complementarity would lead, at best, to an investigation regarding only a limited group of victims represented before this court, those who were victimized only in Afghanistan in the very narrow territorial scope of the conflict in Afghanistan. However, any investigation by the state of Afghanistan would not and could not address the crimes committed by the victims of the torture program created by Mr. Jessom, Mr. Mitchell, and the CIA. This would leave behind Mr. al-Nashiri and other victims of the kidnapping, rendition, illegal, multi-year imprisonment, and torture at the hands of the CIA and actors of all the states, including Rome Party states, who cooperated with this agency. We ask that the appeal chamber change the decision of the pretrial chamber and authorize the investigation. We ask that the appeal chamber do so in a way that leaves no doubt that the grievous crimes committed against Mr. al-Nashiri do not fall outside the scope of the investigation. Any other decision will leave Mr. al-Nashiri without justice, the truth of his suffering untold, his rights and freedoms unvindicated, with no chance of an effective investigation and no perspective of accountability for the perpetrators of the terrible crimes he suffered. The decision of the pretrial chamber is legally flawed, unjust, and if left unchanged, will result in impunity and injustice. Thank you.
Thank you very much, Counsel. Because we have saved some time, we will adjourn for the lunch break now. And I propose to meet again at 2 p.m. to continue the hearing.
All rise.